not so. It's only a power that is clothed upon the investigator, not upon the state government. If my lord were to read section 173 subclause 8. However, my lord, the fact remains that the government would order for further investigation.
Government orders.
Government orders further investigation despite the dismissal of the writ petition and also the special petition by the Supreme Court. Doesn't matter. My lord, further investigation came to be taken up. Additional report.
5 years ago.
Yeah.
Further investigation orders 2019.
Yes. My lord, the issue is this. Let them file. Doesn't matter. I was aggrieved, my lord. Subsequently, I filed. Additional report came to be filed. It can't be a supplementary charge sheet or a fresh charge sheet. It is only a report which is additional to the report that has already been filed. That is how, my lord, the language of section 173 8 says. My lord, well, have a look at section 173 subclause 8. It can't be a fresh charge sheet or a supplementary charge sheet. It is a report which is filed in addition to the report that is already filed.
What do you say the report?
Well, yes, I shall come
The
to that.
charge sheet filed under 173(2) is also termed as a final report.
Quite right.
The same way, this is also a report.
Yes, my lord, that is exactly what I am saying. Now, have a look at 173 subclause 8, my lord, for a
Yes.
second.
Yes.
Although my lord would be coming across the day in
Yes,
and day
yes.
out. Just for my satisfaction, let me invite
Yes,
my lord's
sir, yes.
kind attention. Let me not
Yes.
be mistaken, my lord. Nothing in this section shall be deemed to preclude further investigation. Yes, my lord.
Yes.
In respect of an offence, after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form. That means it will be a further report to the report that has already been filed. No quarrel about that.
Yes, sir.
Immediately with the trial is likely, trial has already been over. Trial has come to an end. It is a case where the trial is yet to commence. But here he files a list of witnesses. First day, second day some other witnesses, third day some other witnesses, and he does not even summon or secure the presence of a witness who has been examined in part.
No, now we'll have to answer. What is the purport of the word new trial in subsection 4 of section 2 and 6? If that is taken note of, then whether witnesses can be brought in afresh.
Well, 216 subclause 4 comes into play, or it could be pressed into service, provided the trial has not commenced. Here in the instant case, trial has already commenced. That means recording of evidence is almost over. 65 witnesses have been examined. Now, my lord, charges came to be altered or added. Then, my lord, the procedure which the trial court is required to follow is under section 217, not under section 216(4).
Recall of witnesses.
Yes, my lord. Chapter 18, no sooner the final report is filed, under 226, my lord, the prosecution is required to state its case.
Yes.
227, my lord, the accused can make his submissions for an order of discharge. 228, the court can proceed to frame the charge. Thereafter, my lord, 229, 230 evidence, recording of evidence. That means, again, my lord, reopening of the case for a fresh trial. It can't be done. That is the law. Next time, he would file another list of witnesses.
Repeating those very...
No, some other persons. Well, that is what the Supreme Court has condemned. May I just invite my lord's kind attention to the judgment of the Supreme Court.
So according to you, 217 permits recall of the witnesses and not bringing in new witnesses. Yes.
216(4) is only in relation to a case where the trial has not commenced.
That we'll see.
Here, the trial has commenced.
No, 216 deals with alteration of charge. Now, alteration of charge, commencement of commencement of trial or conclusion of trial has nothing to do with alteration of charge. It can be altered at any time.
Anytime it could be.
At any time.
As my lord
The
has
procedure after that is under 216(4) and 217 is what we'll consider it. Yes.
I was